Hello, everyone. My name is Eric Eisenman. I'm a partner in Husch Blackwell's Milwaukee office, and I'm chair of the firm's National Labor and Employment Practice. I am delighted to welcome you to the Wisconsin edition of our Labor and Employment virtual series. I suspect that many of you joined us back on October 12th for our national presentation. That was followed by our program in Kansas, Missouri, and Illinois on October 19th. And our Texas program on October 26th. If you are interested in viewing any of those sessions, please contact our events team or send me an email, and we will be happy to send you a link to the recordings. You can also find those on our website. We have a terrific Wisconsin presentation for you today. But before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We will have real, live Husch Blackwell attorneys responding to your questions during the webcast today, as time allows. A PDF of the presentations and other resources are available in the Resources folder. This program has been approved for HR and legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with the recording of this webcast for watching or sharing. Towards the end of the program, please be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That's all for housekeeping items, so let's get started with our program. As you already know very well, the changes in labor and employment law have been coming fast and furious lately. So we hope to cover a lot of ground in our scheduled 90 minutes today. To begin, Laura Malugate and I will discuss substantial rise in wage and hour class action lawsuits we've observed in Wisconsin and identify some key areas of risk for employers. After that, Tom Godar and Katerina Cologne will address strategies for hiring and retaining quality employees and tactics for removing barriers to hiring, including consideration of marijuana and drug testing. Next, Tom O'Day will provide an update on COVID-19 in Wisconsin, including the most recent developments regarding vaccine mandates and pending legislation on unemployment eligibility for employees who are terminated for refusing to comply with those mandates. That'll be followed by Scott LeBlanc and Caitlin Doyle discussing the evolving law in Wisconsin on noncompetes and other restrictive covenants, including the Biden administration's recent executive order on this topic, and some antitrust considerations for employers to assess. Finally, David Eckhart and John Anderson will close us out by discussing some key recent developments in employee benefits and traditional labor law. Laura, I'll ask you to introduce yourself and get us started.
Thanks, Eric, and welcome everyone. My name is Laura Malugate. I'm so glad to have you with us here this morning. Eric and I will be talking for a few minutes this morning about wage and hour class and collective actions, which, as many of you know, continue to be on the rise in Wisconsin and continue to be a source of significant financial exposure for employers. This is an area where there are verdicts and settlements that range in the millions, if not tens of millions of dollars. And just like everything else we've seen lately, it's an area that's been significantly impacted by the COVID-19 pandemic as well. In fact, many of the wage and hour class action issues relating to the pandemic are just now really starting to get litigated and are making their way through their courts. And the courts will be grappling with these issues for years to come, really. So before Eric dives into some Wisconsin-specific issues, we wanted to first give you all a refresher course on federal law and highlight some common issues that we see. As many of you know, the Fair Labor Standards Act obligates employers to pay minimum wage and overtime. In addition to minimum wage, the FLSA requires employers to pay non-exempt employees overtime compensation at a rate of at least 1.5 times the employee's regular rate of pay for all hours worked over 40 in a work week. Now, you might read that and say, well, that seems relatively straightforward. How hard and complicated can that be? Well, I wish it was that easy, but it is actually, there's a tremendous amount of detail and litigation that goes into that single sentence alone. So if we break it down, starting with the simple fact that overtime is only required to be paid to non-exempt employees, it begs the question, well, what's an employee under the law? We have to consider whether you have independent contractors that should actually be classified as employees. Do we have joint employment situations? Do we have interns or volunteers that might fall under that category? And of course, do your employees actually qualify for an exemption? Then what is that non-exempt employee's regular rate of pay within the meaning of the law? So this is more than just their straight regular hourly rate. This, generally speaking, includes all compensation that an employee receives, except for certain specified items that are excluded. And then once we figure out the regular rate of pay, we have to look at, well, what is hours worked for purposes of getting up to that 40 hours? What falls within that bucket? We have to think about waiting time, travel time, pre and post shift activities. We have meal periods, rest breaks, charitable activities, training time, all of which falls within that category. And then of course, what is the work week? How is that defined? What if that changes? So, practically speaking, we could probably spend an hour talking about each of those 4 words on your screen right now. But thankfully, we will not bore you with that today. So what kind of claims do we typically see under the FLSA? Well, it really runs the gamut of all the things that I just talked about and more. I've already touched a little bit on misclassification, but another big one relates to the failure to properly calculate the regular rate of pay correctly, particularly as it relates to bonuses. So the regular rate of pay includes non-discretionary bonuses, but it excludes discretionary bonuses. So under the law, a bonus is only discretionary if it meets certain statutory requirements. So for example, the company must retain discretion as to whether or not it's going to pay the bonus, how much it's going to pay the bonus, and it can't be something that's paid pursuant to some sort of contract or agreement or a promise through which an employee might expect the payment.
That's an issue that I think we should flag, and we're seeing a lot of. I would say the vast majority of employers that we advise probably pay what they consider to be discretionary bonuses and exclude them from that overtime calculation, when in fact, if you would assess and analyze under the law, probably should be treating that as non-discretionary and including it.
Exactly, right. And those non-discretionary bonuses must be included in the regular rate of pay. So what does that include? It's things like, bonuses that may be based on a predetermined formula, like individual or group production goals, or certain commissions, attendance bonuses. With respect to the pandemic, we've seen class action litigation stemming here from bonuses that were given by employers at the height of the pandemic. We have, employers saying that this should be more akin to a gift that's totally discretionary in nature, and the plaintiff's bar, in some cases, saying the exact opposite. Also related to the pandemic, we're seeing, class and collective action claims relating to failing to pay employees for certain COVID-19 screening protocols. So this can include things like waiting in line to be tested, getting your temperature taken, other sort of screening protocols, maybe filling out a symptom tracker of some kind, all sorts of things that may have occurred before employees were technically on the clock. Another one I want to touch base on briefly here that's quite tricky relates to rounding an employee's punch in and punch out times, the time clock. So under the Fair Labor Standards Act, it is generally permissible for an employer to round the punch clock, but only if that rounding does not systematically undercount an employee's hours worked overtime. So in other words, the rounding, whether that be up or down, has to eventually even out, or maybe even result in slightly an employee being slightly overpaid. So for example, if a rounding policy may round to the nearest 15 minutes, in theory, that should, over time, sometimes benefit the employee, sometimes benefit the employer, and even out. Now, practically speaking, we can't just look at that rounding policy in a vacuum, though. We have to think about other ways that that employees might be on their work might be undercounted. So that can be human error, like a supervisor reviewing the time clock and not getting it accurate, or even the way your rounding policy interacts with your attendance policy. So we have to look at that collectively. Now, these are just a few of some tricky issues that we face and under the federal law. And with that, I'll pass it off to Eric.
Thanks, Laura. Like Laura said, these are issues that employers in every jurisdiction need to be concerned about. I'll touch on now a few things that are going to be specific for Wisconsin businesses. And the one I wanted to highlight here is these Wisconsin meal period claims. This is a unique area under Wisconsin law that is creating a basis for a lot of recent litigation. So a brief reminder, this is actually kind of a common misperception. Neither federal law nor Wisconsin state law requires employers to provide a meal period. They recommend meal periods, but they don't require it. The quirk is that under both Wisconsin and federal law, an employer is not required to pay for that meal period if the employee is completely relieved from duty for the purpose of eating regular meals. What's different between Wisconsin and federal law is how that relief from duty concept is interpreted. The federal law is more relaxed. The Wisconsin law has some very specific elements. In order for your Wisconsin meal period time to be unpaid, the employee needs to have one, at least 30 minutes completely free from work, and two, that they be free to leave the premises. So if you have a policy in place that either provides fewer than 30 minutes for a meal period, or you have a restriction in your policy or your handbook that says employees must stay on the premises during that meal period, you are obligated under the law to pay that time. You should not be treating that as an unpaid meal break. I think many employers often will have that 30 minutes or understand that, but they may not have that language in there that says, you're free to leave the premises. That's an essential component in order to be in compliance with Wisconsin law. So where do we see this pop up, right? It's easy enough to understand, okay, that means I have to implement a rule that says employees have at least 30 minutes to take that meal and they're free to leave the premises. But there are a couple areas where you could push your compliance into a bit of a gray space. One, employees who might be working through lunch. They've got a scheduled lunch, but they're working through that lunch. If you have it set up as an automatic system that 30 minutes is deducted, that is a violation under Wisconsin law. Second, starting or ending that lunch break early, very common here. You might have a policy that says employees are expected to stay at their workstation until 12 and be back at their workstation by 12:30. If that's the case, there creates a risk that the employee is not working a full 30 minutes and could be a violation. I'm sorry, not on a break for a full 30 minutes, and that could create a violation. An employee who's answering phone calls or work emails during lunch, you might see a scenario where the employee could claim that that means that they didn't have that uninterrupted period of time. Poorly trained managers, those who you might have the correct policy in place, but when they're communicating those expectations to employees, are implementing a policy basically that shortens that period, or basically impractical policies that you have in place that make it just impossible to comply. So those are the areas under Wisconsin law that we're seeing risk for a violation of this claim. And I'll pass it back to you, Laura, to talk about what really the risk is.
Yeah, thanks, Eric. As compared to single plaintiff litigation, this is really an area where we see a tremendous amount of financial exposure. So employees here can file a claim on behalf of themselves and other employees who are similarly situated and seek back pay, liquidated damages, and attorney's fees. Because the back pay violations that are associated with these sorts of claims, especially the meal period claims that Eric was just talking about, can be relatively minor for each individual employee. These are usually brought as a class claim, which, really magnifies the cost in terms of both defending it and in terms of the verdicts and the settlement. So it's something that should be taken very seriously in terms of what can be done to help avoid these claims in the first place. So things like training and shoring up your policies and procedures.
Thanks so much, Laura. I know we covered a lot of ground there really quickly, but I think the key point that I want our audience to take away is there are a lot of potential pitfalls there, a lot of spaces where an employer might think that it is in compliance with the law, but in fact, it is actually not complying. Perhaps your policy allows the 30 minutes, but does not allow the individuals to leave the workspace. Perhaps it's a scenario where you've got the 30 minutes in there, but instead it's a scenario where the employee is not allowed to leave her workstation or needs to be back by a time that doesn't comply with that law. And as Laura suggested, this is just an area where we see enterprising plaintiffs' law firms really taking advantage of these quirks in the statute. There are really a handful of firms which are familiar names to us, which we've seen over the last 3 or 4 years really increase in frequency the number of actions that they're bringing in this space. So the best way to address that, as Laura suggested, contact your friendly outside counsel to help review your policies to ensure that you're in compliance. I'm going to transition next to our next speakers. We have Katerina Colon and Tom Godar, who will be talking about hiring and retaining quality employees. Some interesting topics. I'm eager to hear what they have to say.
And good morning, all. I'm Tom Godar. Katerina's to my left, and it's great to be with you. And of course, we get the coolest topic.
That's right.
We have the one that all of you are concerned about, and we don't really have the magic bullet, do we?
No, I wouldn't say the magic bullet.
Let me tell you a little bit about our agenda. We're going to talk about the big issues that relate to attracting and retaining your best qualified candidates. Katerina and I will go back and forth, as Laura and Eric did just before us, walking through some issues which probably aren't a process exactly for you, but we hope that out of this, you might be able to take out a handful of really great nuggets. So as we move forward, I want to start out with just the regular old blocking and tackling, the legal framework. As all of you know, Title VII means that we cannot discriminate based on race or color, national origin, sex, sexual orientation, transgender status, and the list goes on. Federal law protects not only those issues, but it also protects discrimination based on age and age 40. That's usually a quiz if you were a live group, and I find that a lot of people are still unsure. There's also disability discrimination laws, and of course, protecting the safety of our employees and our third parties who are visiting under OSHA laws. All of this legal framework is necessary to be complied with when we're talking about attracting and retaining employees. As this is a Wisconsin-specific presentation, we also have state laws that provide against discrimination based on creed or color, disability. The list goes on, and a few of the exceptions that might not be found in Title VII or in federal law include discrimination based on marital status, a discrimination based on arrest and conviction records, and I still get many calls about that every year. Military service is protected under both federal and state laws. Interestingly, and we'll talk about it soon, the use or non-use of lawful products off premises, we used to call that the cigarette smokers protection law. Now it may affect employees, at least we can talk about it, who are legally using prescribed medications, but they might be perhaps working in an unsafe manner. So this legal framework not only provides a shield for the employees, quite honestly, it provides a great reminder for those of you who are hiring, because not only do you not want to discriminate against those who are different perhaps than your traditional workforce, whether it's race or age or transgender status, we're going to urge you to look carefully at all that you can gain by looking at those who might not have been a traditional part of your workforce to be an attractive employee to hire or retain. Why don't you take a little bit of time and talk about that, Katerina?
Thanks so much, Tom. I'll take that. All right, so now that we've laid the legal groundwork, let's discuss how employers can attract quality candidates. But before we begin with the tangible steps that you can take, it's important for us to address some notable but not that surprising statistics. So more than 3 out of 4 job seekers and employees report that a diverse workforce is an important factor when they're evaluating companies and job offers. That means whether or not your company is interested in increasing its diversity, most candidates are nevertheless evaluating diversity when they research your company and during the interview process. Having a diverse workforce is particularly important to underrepresented groups. Again, not that surprising. Nearly a third of employees and job seekers would not apply to a job where the company has a lack of diversity amongst its workforce, and that figure is significantly higher for racially diverse job seekers and amongst LGBTQIA job seekers. So the point being is that diversity should be something that's taken into account when you're evaluating your hiring and recruiting process. It's also worth noting that your employees also think you should be doing more. More than 50% of employees want their workplace to be doing more to foster and increase diversity. And while there are many reasons to strive for an inclusive workforce, including great innovation, improved morale, increased retention, because it's the right thing to do, all companies should be aware that ethnically and racially diverse companies are more profitable as well. So let's transition into your candidate review process. What are some tangible steps that you can take to attract quality candidates? So as a first step, you should be reviewing your job postings for a couple of things. One, is your job description clear? So this might seem pretty obvious, but a study of 1,400 employers and 13,000 job seekers found that 72% of hiring managers say that they provided clear job descriptions, whereas 36% of candidates felt the job descriptions were not clear. So that's a pretty notable gap in terms of how they're perceiving these job listings. Your effective job description should be unique to your company and exclude arbitrary requirements such as skills that can be learned on the job. We also recommend completing a careful review of the language used in your job descriptions. Hiring managers who are trying to appeal to as many candidates as possible should try to strike a balance between skill-based qualifications and individual characteristics when creating job descriptions so that candidates aren't dissuaded from applying based on minor word choices. For example, there are studies that show that women are discouraged from applying to positions where the term aggressive is used in the job description. If you switch that out with strong-willed or powerful, you're going to be ensuring that you're not missing out on quality candidates by your language use in your job postings. Finally, we recommend that you conduct a review of your resume review process. A study out of Boston and Chicago found that applicants with white-sounding names needed to send about 10 resumes to get one callback, whereas applicants with African-sounding names needed to send about 15 resumes to get one callback. It's also worth noting that this study accounted for equal work experience and educational background between the candidates, but there was still a 50% callback difference, which is pretty striking. One way that employers can address this gap is by conducting what we call blind screening, and that's essentially by including a statement in your job posting that requests that candidates exclude their name and college graduation date from their application materials. Alternatively, you could task someone in your company with the job of removing identifying information on the application materials so as to ensure that whoever the hiring manager is, they're only taking into account that individual's qualifications and not basing any hiring decisions off of their protected characteristics. We also recommend implementing an employee referral program. This is just another option for you. This is a recruiting strategy in which employers encourage current employees, typically through rewards, to refer qualified candidates for jobs in their organizations. This strategy is popular because employee-referred new hires tend to be better performers and they tend to stay with their organizations longer. Employee referral programs are also more cost-effective than other recruiting strategies and are often the fastest way that you can find external talent. And actually, over the past decade, around 30% of new hires come from employee referrals. And it's also worth noting that these programs may create unintended disparate impact claims if employees refer candidates of the same race, religion, or other protected characteristic. Employers can mitigate this risk by evaluating all candidates using the same evaluation criteria, keeping the employee referral program open to to the entire organization and not just certain departments or divisions, and conducting an ongoing analysis of the workforce and your applicant pool to ensure that the program is effective and yielding the intended results. Okay, so we've got our slate of candidates now, and we need to start conducting interviews. We've listed some best practices for you here when you're conducting your interviews, starting with making sure that your interviewers are trained on these best practices. We shouldn't be sending employees into interviews without first providing guidance or training on what questions are appropriate and how to best take notes on candidates during interviews. The information sought from each candidate should be similar. And an easy way to do that is having a list of standardized questions that, that hiring employees can ask of each applicant. You also want to have a procedure on how to handle uninvited information related to a protected characteristic. So we obviously can't control what information applicants divulge during their interviews. However, we can prepare with how to address those situations when they arise. So for example, if you have an applicant who discloses that she's pregnant, instead of saying the natural follow-up question, which is, oh, how far along are you, right? You could simply say, congratulations, and move on with the rest of your interview. We also want to avoid conducting any independent research that may bias us during the interview process, such as looking at the applicant's social media pages. You know, as enticing as that might be, we want to try to stray away from that. As an example, I went to UW-Madison for undergrad and law school. If I, I'm looking on somebody's social media page and see, oh, they're a fellow Badger, before even looking at what their qualifications are, I might be biased toward that candidate simply because we have something in common. So we want to be aware of those biases during the interview process and make sure that we're not allowing it to affect our judgment. And now I will turn it over to Tom to discuss marijuana testing and the developments in that area.
You know, one of the stories that came to mind as you were talking, Katerina, was the employer or interviewer who put down too old on the resume that the employee had provided, or the candidate had provided. They were referring to the computer instruction and the courses that they had taken, but it wasn't very clear. So when you take notes on these things, you have to be clear about what it is you're looking for.
Absolutely.
Speaking of clear thinking, marijuana testing before and during employment. I'm all for it, except when I'm against it. It's a tough one. We have more and more employers who are saying that there's a fairly high percentage of people that have tested positively. Indeed, a study conducted by, I think, NIDA, the National Institute for Drug Use, found a 24% increase from 2014 to 2020 in those who are testing positively. But in the meantime, while it's illegal in Wisconsin to sell or use marijuana, it's not, and certainly we talked about the Badgers, not so much in Dane County, but in any case, we're surrounded by places where it is not illegal. We know it's not illegal in Michigan and Illinois. I think Minnesota is medical marijuana. And so people are using this legally, and many of our employers, our clients have said, I'm not sure we're going to test for this anymore, at least given the candidate pool shrinkage. Now, we have many who are involved in healthcare, transportation, other industries where it's important to test for safety concerns. But one of the problems that you have with testing is even knowing what has been the impact on the employee of using that substance many hours or even days before, which can sometimes test positively. Consequently, you are concerned about impairment during work hours. That's your real issue, not about whether a test came in positive or negative. It's difficult to know that, again, going back to training for candidate selection, training for looking at whether people are impaired is an important issue. And so we're going to leave it to you, our clients, to determine whether it's absolutely necessary. But I can tell you many of our clients have made a move to move away from marijuana testing before and during employment. So one of the next places that we want to go to is retaining these great employees that you've now hired. Would you take that for us? Oh, no, I think I'm going to keep going.
Yeah, this is on you.
That's on me. I'm sorry about that. One of the areas that I feel really strongly about is highlighted number one on the slide that you're looking at, onboarding and orientation. I had a client that had many union facilities across the country, and their plant manager said, I'd like to open a non-union facility, not because of anti-union bias, but because he believed that there could be some great flexibilities that could be brought into that. And in fact, part of the importance of that experiment was onboarding and orientation, which did not take place over a day, but over weeks. And guess what? It was the outstanding plant doing what others were doing. Onboarding and orientation can't be overemphasized to retain a quality employee. Mentorship programs, looking at people having somebody who's really protecting their interests in that first year or even two as they move through the complicated system of employment. Of course, compensation must be competitive. Perks, well, what are those? They can be almost anything. The perks that you can offer can go to not only workplace flexibility and flexible schedules, but also it goes to, catching people doing well. Wellness offerings are one of those perks that's listed below that can be offered. And communication, unfortunately, most of our employers, our clients, get a C, maybe a C+. It's really hard. It takes a lot of work and focus to get an A, but employees want to know what's going on. The continuous feedback on performance rather than having just an annual evaluation is an important issue, I think, as well. Training and development. People want to know where they're going, what the opportunities are, and they need the training both in-house and perhaps outside, given that you're basically respecting your employees. The same would be true with recognition and rewards programs. But the next one perhaps is one of the most important. Millennials and others are having a real independent decision-making about work-life balance, and we have to help them with that. In the flexible work arrangements, people are coming back from COVID, and guess what? 1 out of 3 professionals are saying, I'm not coming back if you're making me come in every day. Work with that. Be flexible and emphasize teamwork. Almost everybody feels they have some leadership skills, but certainly everybody also believes that working in a team not only can be, but is a better way to walk forward. Acknowledgement of milestones, whether it's personal ones or professional ones, really important. As we take a look at the employment policies, you might have to say, I'm going to do something different as a result of this. How do we put in policies that don't have cultural preferences? How do we look for maternity leave and parental leave being different? I didn't ever take parental leave. I just didn't really think men were supposed to. That's not the way we should go. It was a bad mistake on my part not to push that a little bit harder. The same thing is true with clothing and grooming practices. I was with a senior HR person. Her son is a tattoo artist. The world's changing. And as the world changes, your policies have to change too. So let's talk about one more area that's really important to have in mind as you're looking at retaining employees.
Thanks so much, Tom. And before we do that, I'm actually going to go back to this previous slide and just to make one more note. With respect to the parental leave, you're not only welcoming fathers into taking parental leave, but also non-traditional parents, right? So LGBTQIA individuals, you have people that are using surrogates now. So just be cognizant that there are different definitions of what a parent is, and that revising your policies to reflect that will create a welcoming environment for your employees.
Thank you. Excellent.
Okay, so a great way to retain quality employees is by encouraging the support of and creation of employee resource groups, or ERGs. These foster networking, mentorships, and other opportunities for professional and personal development. Historically, ERGs have been centered on race or gender, but these groups are increasingly being created for those sharing other characteristics such as age, veteran status, or sexual identity. So how are ERGs different from affinity groups? Well, affinity groups are more similar to a social club. They tend to be driven by individuals and are inward looking. The purpose of an affinity group is to create a safe haven and to justify cultural reinforcement in the workplace. And from a business perspective, the primary benefit is employees expanding their personal network, which is a great thing. ERGs, on the other hand, typically have sponsorship from human resources. Mentorship becomes more formalized, in part because the ERG is used by human resources in seeking to meet talent and acquisition and retention goals. When they're well run, the ERGs can become a place for the development of emerging leaders who are considered on the high potential track. ERGs can help human resources focus on groups of employees that may be at risk of leaving, and the ERGs can become part of the solution to combat high turnover of employees. So it's really more of a collaborative effort between ERGs and the business. Both ERGs and affinity groups are extremely valuable, and an affinity group can transition into an ERG over time. All in all, ERGs may form in your workplace whether you plan for it or are prepared for it or not. So we recommend working with your employees to make sure that these groups are carefully structured, have a mission statement, and have defined goals by leadership. So consider providing specific tasks for your ERGs, such as having them determine what the company can do to better improve the workplace. Make sure that any limitations on ERGs are applied equally to all groups. For example, you can't prohibit a specific religion from having an ERG if you allow another to do so. And finally, we recommend tasking a company representative with serving as a sponsor or liaison between the ERG members and the company to ensure that ERG's input regarding company practices and policies are being implemented. Tom, is there anything you'd like to add before we wrap up here?
Katerina, that was terrific. And I'm going to summarize much of what we said with some really basic concepts. It's been said that culture eats strategy for breakfast. The whole notion of creating a positive culture, that's really what we're talking about, particularly on retaining people, but it comes through when you're also looking at hiring people. There was a book written by Dr. Robert Sutton. It's called The No Rule. Fill in that blank. It's called Building a Civilized Workforce. You build a civilized, respectful workforce using some of the tools we've talked about here, you will not have nearly the difficulty attracting and retaining great employees. Thanks so much, Katerina. Thank you for joining us today.
Thank you.
Thanks very much, Tom and Katerina. That was excellent. I think so many of us during the war for talent that we've got going on right now are struggling with retaining and recruiting employees in general. But that's even more sort of critical when we talk about diverse talent. I'll sympathize a little bit for those of you who are out in the audience. This is something that our law firm is struggling with. And I think there's a lot of lessons that Tom and Katerina shared already that we could learn when we focus on that. I think one takeaway that I think Tom and Katerina shared, you know, the recruiting is really only half the battle. That ability to retain talent is something that I think a lot of businesses don't focus on as much as they should. So it's time now for our first poll question. We're going to be using these poll questions as a little bit of a benchmarking exercise for you. So if you go ahead and take a look, our first question is, does your company currently include THC or marijuana in a pre-employment drug screen? And if so, are you considering changing that policy? No, yes, and we are considering changing our policy, or yes, and we have no plans to change our policy at this time. So please go ahead and click one of those three options. In a moment, we'll switch to the results so that we can see sort of what the current status is among the attendees here. All right, let's go ahead and see those results. Looks like about 52%, a little more than half, do not currently have that, does currently include that, but is not considering changing it. I think that that's consistent with what I've been hearing anecdotally. A lot of businesses have historically done this and don't intend to change. You can see a little bit of a breakdown there. At each camp, these individual employers fall in. So something to consider. The law is evolving and your policy should probably evolve as well. Next, we're going to switch to the topic du jour, and that is COVID-19, specifically as it relates to Wisconsin. I'm excited to introduce Tom O'Day, a partner in our Madison office, who's going to talk a little bit about all of those things that are front of mind: mandates, vaccines, pending legislation. Tom, please take it away.
Great. Thanks, Eric. It is hard to believe, but this has been a very time-consuming couple days, and I think we could all just benefit from taking a breath in human resources and frankly saying thank you to all of the human resources professionals for all that you've done throughout this pandemic, and specifically over the last couple days. It's just been a lot coming at us with all of these new vaccine rules, and we'll try and break those down here. So there's a lot of data and information available, right? You can see the information throughout the country, throughout our state, throughout your local geography about the vaccines and the status of the vaccines within the workforce. You have the data available at your fingertips. And as employers and human resources professionals, you need to look at that data. Big questions in human resources now are how many of our employees are already vaccinated? is the federal government going to require my employees who don't want to become vaccinated to get vaccinated? Who's going to pay for the tests that the employees might have to undergo if they're not vaccinated? And then ultimately, what are we going to do about the staffing crisis? Those are the questions that are in front of us all every day, and it's something that we're managing through day to day as new information and new guidance comes out. We're at a point now where we've got those 3 federal vaccine mandates, and we'll run through each of them briefly here, and then at the end of my time today, I'll touch on some resources that are available for future use with respect to each one of these different requirements. So the federal contractor rule regarding vaccines came out first a couple weeks ago now. I tell you at base, if you have a federal contract compliance officer reaching out to you with language that they want to add to your federal contract, don't just take it lock, stock, and barrel. Reach out to an attorney, reach out to an advisor, and review that language and make sure that it's not something that is requiring you to do more than might otherwise be required under those federal contractor rules. Last week on Thursday, we had the unpublished version, and on Friday, we had the published version of the CMS, Centers for Medicare and Medicaid Services, vaccine rule, and the OSHA rule related to employers of 100 or more employees. First, with respect to the CMS rule, I'd say no surprises. It's a hard mandate that applies to healthcare entities that participate in Medicare or Medicaid. It does not allow for an option for employees to just test instead of getting the vaccine. It does require employers to comply with federal law with respect to religious, disability, and other exemptions. The OSHA rule applies to employers with 100 or more employees. Lots of questions related to the OSHA rule are still outstanding. I expect, given the Department of Labor's recent history with respect to COVID issues, that we'll get a fair amount of guidance over the next couple days and definitely over the next couple weeks that really addresses some of those bigger issues that we as healthcare professionals are identifying within the workplace. And then there are going to be some of the employers that just aren't covered by any of these rules. It's those employers with less than 100 employees, and get ready for all the recruits and applicants. I think there's going to be a lot of people shaking out of the workforce and looking to places where, for whatever their personal reasons are, they don't want to be vaccinated. And I suspect we're going to see somewhat of a shift when we get there. All 3 of these rules have been challenged by litigation. The state's attorneys general, and governors across the country are challenging each one of these states or talking about different challenges. I tell you that the OSHA rule, I think, is on the shakiest ground. One of our colleagues, who's pretty close to all things OSHA, commented that he thinks the ETS is on very shaky ground. OSHA has always struggled with challenges to emergency standards, and its track record is terrible. Since 1971, OSHA has issued 9 emergency standards, 6 have been challenged, and OSHA lost 5 out of the 6. So the bar is really high, and we seriously doubt, or this colleague of ours seriously doubts, that OSHA will be able to clear that bar. So something to watch for as you work through the process of each of these individual requirements related to vaccines. Have that team together internally, work with your close advisors externally to make sure that you're on the right path moving forward. And again, there's a lot more detail and resources that we'll touch on at the end of my 20 minutes today. Some of the different considerations that you and your internal team can start thinking on are, 1, what are the policies we currently have in place? And what changes do we need to make to those policies? So at each level of the federal contractor, the CMS, and the OSHA vaccine rule, there are specific requirements that employers need to implement in order to come into compliance with those rules on the timelines laid out within those rules. And it's best just for great human resources service to review those policies and make sure that they come into compliance and that they also match the culture and the approach that you've taken within your particular workforce. Communicate and educate employees about the vaccine. You hear all the time from Aaron Rodgers to others that are critiqued for being spreaders of misinformation about the vaccine. There is accurate information. The Centers for Medicaid and Medicare Services provides a fair amount of detail about the vaccines themselves that you can use in the workplace. And there's lots of tools available to make sure that your employees are making an informed decision when they make these decisions related to these mandatory vaccines or potentially options for testing. You'll need to implement a system for the accommodation requests. You're going to get a lot of religious accommodation requests. You're going to get a fair amount of disability or medical accommodation requests, and you need to plan for that. It's a fairly regimented process. The review itself, when you get those details in the door, can be very fact-specific, and you have an obligation to really consider individually, case by case, which exemptions to grant and which exemptions to deny. And we'll touch on some of those considerations a little later. Train your managers and supervisors about the exemptions. Those stray comments and things that the manager may say off the cuff to the employee about their sincere religious beliefs or a medical condition that they might be claiming can lead to liability. So you need to make sure that your managers and supervisors are trained with respect to their obligations, the requirements that you as an employer have of them, and also make sure that they know what to watch for with respect to exemption requests, and make sure that employees know that there won't be any retaliation for any employee who makes that kind of exemption request. Both the CMS rule and the OSHA rule talk about the confidentiality of the information that you're gathering, the type of proof of vaccination that you collect, the exemption requests that you get in with the detail behind the actual request itself is confidential. You'll need to take steps to ensure that that information remains confidential while also being documented for any compliance investigators that may knock on your door. And then finally, it's not a surprise, all of the rules still require those safety controls and infection prevention measures at varying degrees. We had a discussion internally within a group here in our law firm yesterday about some of the misperception of clients that just because the OSHA rule says vaccinated people don't need to wear masks, that they shouldn't wear masks. And if you read the fine language within the OSHA rule, OSHA is still strongly encouraging masks. And OSHA still has a lot of authority and a lot of power to enforce the infection control measures that they think are important for the general safety of the workplace. So those kinds of infection and safety concerns, protocols, and measures that you probably have in place now and have had in place for 18 or so months probably need to continue in the future, and OSHA's probably going to be looking for those. We talked about the exemptions, and frankly, you'll hear a lot about those over the next couple weeks. These exemptions and the process to work through these exemptions is not a surprise. Healthcare employers in particular have been dealing with these exemptions and requests for these exemptions for a fair amount of time, for a couple months now that healthcare employers have been working through these vaccine mandates. The religious, the medical, the disability exemptions are all fairly straightforward under federal law. Your employees can request them, and then you should have a review committee internally that has a consistent standard that they look to in order to approve, request more information, or ultimately deny those exemption requests. I'd say in the both OSHA rule, the CMS rule, and the federal contractor rule, there really weren't any surprises with respect to the exemptions and what they offered, maybe with one exception. In the CMS rule, they made a comment about state laws that give broader protection for religious or disability or medical needs in the workplace. And CMS said those state rules that provide broader protections are preempted by federal law. So the state of Iowa is a good example. Within a 24 or 48-hour period, the state legislature and governor passed legislation that gave employees in Iowa greater protection to claim a religious type exemption. Under the CMS rule, and likely how OSHA interprets their rule, that state law would not apply because the OSHA and CMS and the federal contractor rules preempt those state rules in the mind of the federal government and the Biden administration. So it's something to keep in mind as you work through those exemptions for employees who might make claims under state right of conscience laws or other state protections that the federal contractors and compliance investigators aren't likely going to consider those relevant or protective for those employees. With respect to accommodations, it's important to note that the standard for accommodating a religious request for exemption is lower than the standard for granting a disability or medical exemption request. If there is more than a minimal burden on an employer, the employer could choose to deny a religious exemption request. And I tell you that a lot more employers are starting to make that distinction between a request for a religious accommodation and a request for a disability or medical accommodation. Because that standard for a religious accommodation is lower, employers are feeling more emboldened to deny a religious exemption request. One big tip related to religious exemptions: to the extent that you do grant a religious exemption, I'd encourage you to do it in a very express, temporary way. The vaccines could change, and religious objections to vaccines could be irrelevant in the future, depending on what science brings with respect to vaccines. In addition, I think you want to reserve that flexibility to determine it's an undue burden now, even though we're granting it, so that you can deny it down the road as a religious accommodation if you need to, because it remains that undue burden that, for whatever reason, you or your employer just don't want to provide. Let's talk Wisconsin and fascinating stuff. The federal government's been very clear. The Biden administration has been very clear. State law is preempted by federal law. Federal law rules. And like I said, in Iowa and other states, there's a lot of states that are passing laws meant to protect employees in those states from these federal vaccine mandates. The federal government is very clear that state law is preempted. In the state of Wisconsin, though, there's a statute, and in many other states, there are statutes that do require employers to pay for any cost of medical exams that employees are required to undergo as a condition of employment. And in Wisconsin, you see the statute here, section 103.37, and very straightforward statute. No employer may require any employee or applicant for employment to pay the cost of a medical examination required by the employer as a condition of employment. Until just this morning, it wasn't clear, because there's no case law out there. There's an attorney general opinion from in 1980, I think it is, that wasn't addressing the question we have of, does this mean that you as a Wisconsin employer have to pay for the cost of any COVID testing? And just this morning, my colleague, Beth Zutti, got confirmation from the Department of Workforce Development that the Department of Workforce Development, in breaking news, does not think this statute requires employers to pay for the cost of COVID testing. So the department interprets 103.37 as not requiring employers to cover the cost of COVID testing, where the testing is an alternative to vaccination, and where the vaccination testing requirement is mandated by the federal government. So literal breaking news. I was on a couple webinars yesterday where the big question in the room was, does this statute require you as an employer to pay for those tests? For Department of Workforce Development purposes, the answer is no. Courts may decide otherwise, and there's still an element of risk you'd be undertaking to the extent that you require employees to pay for those tests. But it's clear under the federal OSHA rule, it's now clear from the Department of Workforce Development in Wisconsin that employers do not need to pay for those tests. Again, that doesn't mean that a court will ultimately decide that way, but at least there's some guidance, some clarity. I mentioned right of conscience laws. Illinois in particular was one that had a fair amount of activity with respect to a right of conscience law that gave more protections for employees, not necessarily based on religious reasons, if they were moral reasons. Or if your conscience, for whatever your personal reason was, said, I don't want that vaccine, that law, in theory, could have protected you and given you the right to deny that vaccine requirement from your employer. Like I said, many times, federal law preempts state law in the mind of the federal enforcement agencies, but it's something to be mindful of. You will see these kinds of objections and references to right of conscience laws. There's Wisconsin state constitution language about the right of conscience. So you'll see these issues, but it's important for you to educate your employees that the federal rules really do govern. And then in Wisconsin, at the beginning, very beginning of the COVID pandemic, it may have even been in the month of February 2020, I think, our state legislature and the governor signed into legislation protections for employers from civil liability due to COVID-19. To the extent that an employee, an individual at your place of business contracted COVID-19, there are state protections in place for you as an employer against that civil liability. Two other notes, pending legislation, nothing necessarily that has passed. The Republicans in the legislature are trying to pass legislation that would require the Unemployment Insurance Division to pay for the unemployment benefits of any employee who is terminated or who resigns employment because the vaccine was a condition of employment. I tell you that's not likely to pass by the governor. The second current pending legislation is related to workers' compensation and the idea that if an employee is required to get the vaccine and is injured because of that requirement, that is presumed to be caused at the place of employment and therefore covered by workers' compensation law. That one's not necessarily so clear whether or not it'll pass, but as most of you know, the current legislature is at odds often with our current governor. A couple notes, and there's a lot to unpack here. And again, it's been a busy 5 or 6 days since we got word of what these different requirements were. Husch Blackwell is there as a resource for you. And I've noted here on this slide a number of prior webinars that we've done related to thought leadership on these different areas. You see one about the federal contractor rule that we had, I think it was just last week. We had a roundtable discussion around the religious exemption and what that meant for healthcare employers, but a lot of those issues will relate to non-healthcare employers now that most of you are subject to one or another mandate. And finally, at the bottom there, legal considerations generally for the vaccine mandates and what was to come. So those are prior examples of thought leadership on our website. In addition, we've got some future webinars coming up as well. This upcoming Friday, we'll be touching on that CMS rule, Centers for Medicare and Medicaid Services, the hard mandate. And then next week, we're looking at hosting a webinar related to the OSHA vaccine mandate. So I'd encourage you, now that we've taken time for some breaths, to dig right back into it. And remember, Husch Blackwell is always here as a resource for you as you navigate these different issues.
Thanks very much, Tom. Really excellent stuff. I'll emphasize the point that Tom made there at the end. You know, you could probably be saying to yourself, Tom could probably give me an entire webinar on this topic, and that's exactly what we're offering. Upcoming on the 12th and the 17th. If you haven't received invitations for those, you can find that information on our website. Full webinars on the CMS rule and the OSHA rule. The other thing I'll point out, and Tom mentioned this, the key date for you guys to keep in mind, when the OSHA emergency temporary standard was issued, it aligns the compliance date of these various statutes. So assuming that OSHA rule survives and these other rules survive as well, you know, that date by which employees are supposed to be vaccinated is January 4th, 2022. Originally, that federal contractor rule, and some of you had seen this, contemplated vaccination in early December. It's January of 22, which is the date that we're targeting now. Time for our next poll question. Has your company implemented a COVID-19 vaccine mandate of some kind? Option 1, yes, we implemented a policy prior to the issuance of the OSHA standard. 2, not yet, but we plan to do so once the OSHA standard goes into effect. Or 3, no, we're not covered by the OSHA standard, and we have no plans to implement such policy. Please go ahead and click, and we'll see what sort of results we get. It seems like we may not be getting results. And the word off screen is that we're going to have 1 second. We'll see if we can activate this. There we go. Looks like we're starting to get some results in. Let's push those out. All right. Again, looks like we're across the board. Nearly a half of you have not yet implemented a mandate, but intend to do so when the standard goes into effect. Interestingly, about 33% already took that plunge. I think that's one of the big takeaways we've seen from the implementation of these standards, is that it's creating a basis for employers who may have wanted to move towards a mandate to do so with the cover of federal law. With that, we're going to transition to our next topic, restrictive covenants in Wisconsin, recent developments in that space by Scott LeBlanc, who's a partner in our Milwaukee office, and Caitlin Doyle, one of our associates. Scott and Caitlin, please take it away.
Great. Thanks, Eric. So you could say that paying attention to restrictive covenant law is a little bit like going to the dentist. You might be able to put it off for a little bit, but if you wait too long, you're going to regret it. And so what we intend to do here is to do a little bit of a teeth cleaning, a quick checkup for 15 minutes just to give you an update on what's going on restrictive covenant law here in Wisconsin, and then also give you a little bit of color of what's going on at the national level as well, where there's some interesting developments going on there and how that might affect how we generally look at restrictive covenants in Wisconsin. So just to give a little bit of background, when we are talking about restrictive covenants, really what we're talking about is 4 different kinds of restrictions. Sometimes people, and we fall into this trap as well, will refer to all of these types of restrictions as non-competes. But really, there are 4 different kinds of restrictions that we tend to see in employee contracts. And really where they come into play is when an employee leaves the company, what sort of rights do you have to restrict that employee's ability to engage in certain activities after they leave? So the first kind of restrictive covenant is what we call the traditional non-compete. And that is basically what it says is that an individual is prevented from working for or owning another competitive, working for a competitor or owning a competitive company for a certain amount of time after they leave employment. Another kind of restriction that we tend to see is customer non-solicitation restrictions. These prevent individuals from soliciting, reaching out to, trying to market to the customers and the clients that they worked with their prior employer. We have employee non-solicitation clauses, which are like customer non-solicits, but apply to the employees of the prior employer to say that you can't recruit your former coworkers to come work with you for a competitive enterprise. These are sometimes called no-hire provisions or anti-poaching provisions. There's lots of different kind of variations on that. And then finally, the last type of restriction are non-disclosure of confidential information and trade secrets. In Wisconsin, those are considered to be restrictive covenants, and they are subject to certain standards. That's not the case in every state. I'll get into that in a little bit more detail later. But those are the 4 kinds of restrictions that we're talking about when we're talking about restrictive covenants. In Wisconsin, we have a state statute, 103-465, that governs restrictive covenants in the employment context. And with that statute, Wisconsin is widely regarded as having one of the most employee-favorable states for restrictive covenants in the country. There are a few that go even beyond Wisconsin, California being sort of the most notable example where non-competes are almost entirely unenforceable under most circumstances. But in Wisconsin, it's very difficult to enforce a non-compete. And part of the reason is, in order for a non-compete to be enforceable, no matter what the employer and the employee decided to put down in their agreement, the restriction itself must be necessary for the protection of a legitimate interest, have a time limit, have a territorial limit, and not be reasonable or oppressive to the employee or contrary to public policy. We've had a number of landmark cases in Wisconsin non-compete law over the last 10 years. I'm not going to get into detail of all of these cases right now, but some of the, if you were watching this 3 years ago, one of the most recent case was the Manitowoc versus Lanning case, which said that employee non-solicits are subject to that statute and need to be properly limited to protect certain specific protectable interests. So you can't just have an employee non-solicit clause that says that you cannot go solicit any employee that you worked with your former employer. It has to be limited to key employees or employees that are difficult to replace based on the special skills that they have. So we are bound by, there's been a number of these changes starting in 2009 with the Star Direct case and moving to Lanning, that we've been sort of continually updating our non-competes since then. But if you've updated your non-compete since 2018, you might be in pretty good shape. We have seen a few recent cases that have shed some interesting light. They haven't changed the landscape from a non-compete standpoint, but they have provided us with a little bit of additional detail and in interpreting some of the prior cases that we have. The first one is the Danaher case. This was decided in 2020, and this was really one of the first cases to interpret that Manitowoc versus Lanning case after it came down in 2018. And what Danaher had tried to do is they took their restrictive covenant agreement and they tried to narrow that employee non-solicit within the scope of what that Manitowoc case said by saying, we're not going to restrict you from soliciting every company employee, but we're going to restrict you from soliciting employees that may have had access to confidential information, which seemed like a reasonable limitation. But when the court got into the details, they decided that basically how confidential information had been defined under the agreement, essentially what they were doing is restricting solicitation to every employee anyway. And because of that, it was too wide and it was unenforceable. A couple of other cases to just keep an eye on. In the Charles Schwab case, the court reaffirmed one of the sort of unique quirks of Wisconsin law, that confidential information restrictions are subject to the time limitations that are required by the statute. So in many other states in the United States, you can have confidential information restrictions that go on indefinitely. That's not the case in Wisconsin law. So you have to, if you're working with employees from out of state or counsel from out of state, you need to be aware that under Wisconsin law, we do need to have that time limitation on our confidential information restrictions. I'm going to skip over DF and just go to the last one, which is the Autochlor case. And in that one, we had an interesting situation where there was a company that was selling its business, and the mother and the father were the owners of the business. The son was an employee. The agreement tried to say that the son had to sign the restrictive covenant agreement as a condition of the sale. And usually, restrictive covenants in a sale are subject to a more forgiving standard. You can stretch them out longer, sometimes 5, 7, 10 years. And what they were saying is that even though the son was just an employee and not an owner, he sort of indirectly received compensation through the sale, and that should give it this sort of extra, this lower level of scrutiny that they should be able to get longer. The court said, no, that's not the case. It was tied to an employment. He was an employee. He was not the owner of the company. And so they went back and enforced the stricter statutory standard. So a couple different things to keep an eye on. Nothing earth-changing, really, from a Wisconsin law perspective, just more clarity on some of those cases that we've seen over the last decade. But where there has been some really interesting developments has been at the federal level, what's going on at Capitol Hill. So Caitlin's going to tell us a little bit about what's been going on there. Caitlin?
Sure. Thanks, Scott. Yeah, so as Scott said, those are all things that have happened in Wisconsin, but there has been some movement in the federal jurisdictions of restrictive covenants as well. So most recently, if you guys were paying attention this summer, in July of 2021, President Biden signed an executive order that encouraged the Federal Trade Commission to create a rule to regulate the unfair use of clauses or agreements that may unfairly limit worker mobility. Now, at a glance, a little bit of panic, right? But let's take a step back. This executive order is not actionable in any way. This was merely an attempt for President Biden to direct his administration into a path that he wants to go in the future. So in suggesting to the Federal Trade Commission that they promulgate this rule, he was essentially alerting the Federal Trade Commission, as well as other agencies that might deal with restrictive covenants, that this is where he wants to take his administration. So the Federal Trade Commission actually in 2020 did an evaluation of sort of this rule of whether they had the ability to regulate a non-compete or restrictive covenants in any way. Now, keep in mind, in 2020, they were under the Trump administration, so change in policy might change the interpretation of what gives the FTC the power to create rules and what they can and cannot cover in those rules. However, that did leave some uncertainty whether the FTC can even do what President Biden is asking them to do in this executive order. Now, keep in mind, if a rule is promulgated by the FTC, it could take months or years to actually go into effect. That will be preceded by public comment and a lot of opportunities for employers to air their disagreements. At any level, the FTC would have to respond to those comments. And it's a very lengthy process to even get a rule promulgated. That doesn't include the legal challenges that could likely result from that, especially given the 2020 understanding that they might not even have the power to do this. In 2020, they said that any rule promulgation would be ineffective and that Congress would have the ultimate authority to regulate in this way. Now, good news, bad news. Congress does currently have a Workforce Mobility Act of 2021 that was introduced in both the House and the Senate. It does have bipartisan support, but it is very unlikely that it will pass this year. However, that does not negate the fact that these introductions of similar legislation have been happening on a pretty frequent manner. So it's very possible that the support, bipartisan support of these types of bills would increase as time goes on, especially with the midterms coming up. And so, we don't quite know if Congress would take this opportunity to regulate non-competes and restrictive covenants in any way. Now, going back to what Scott said, Wisconsin does have a pretty employer-friendly statute. So even if these things happened, even if Congress or the Federal Trade Commission did create some sort of restriction on non-competes, specifically unfair use of non-competes, it's not clear how that would impact Wisconsin employers and if it would do anything to narrow the scope of what Wisconsin already considers to be our bare minimum. So you might be thinking, well, what do we do now? So Scott is going to kind of take over to kind of wrap up and give some general takeaways for you.
Thanks, Caitlin. So, a couple of general takeaways. Some of these are things that we've been telling clients for a long time now. Others are things that we've maybe started to talk about with clients in light of what seems to be a pretty clear push at the federal level to limit the use of non-competes, at least with respect to kind of low-level employees that really might not pose a competitive threat to their employer. So general takeaways, remember, Wisconsin courts will not reform, which is also called blue penciling, unreasonable restrictive covenants. You got to get your restrictive covenants right the first time. If you screw it up, you're going to be in some trouble. We do now have some case law. This goes back to that Star Direct case that says that Wisconsin courts may sever unreasonable restrictive covenants from the reasonable ones if drafted properly. So what that means is that if you have a part of an agreement that's unenforceable, but the rest of the agreement works, if you draft the agreement carefully and in the right way so that the bad provisions and the good provisions aren't intertwined, a judge may have the ability to take that bad provision out and enforce the rest of the agreement. So it's very, we have to be very deliberate about how we draft our agreements to make sure that in case some of the restrictions are going to be found to be unenforceable, we're not taking the rest of the restrictions down with them. So it's really an art to drafting these agreements to make sure that they comply with some of this guidance. The trend on a public business and legislative level is moving away from restrictive covenants. I think employers understand that enforcing restrictive covenants is a very time-intensive and costly process, that when you're talking about run-of-the-mill employees that may not be good employees anyway, that you may just be better off shipping off to your competitors, that trying to enforce non-competes is not a good use of anybody's time. And certainly from a policy perspective, it seems like many politicians, both at a national and some at the state level too, are of the opinion that it is unfair to expect especially low-wage and sort of mid-level employees to stay out of the workforce or stay out of a particular industry for a certain period of time. As Caitlin mentioned, Wisconsin law is already very employee favorable. So if we do end up getting an FTC commission rule at some point, we think that it's probably unlikely to have much of an impact on us here in Wisconsin. Anything that would be agreed on at a federal level is probably going to be less restrictive than what we're used to here in Wisconsin. Although we should keep an eye on efforts to limit non-competes to certain employees and pay ranges. A number of states outside of Wisconsin have taken that approach, where to say an employee must make a certain amount of money per year in order for a non-compete to be enforceable. That's a kind of restriction that I could see Wisconsin moving toward at some point in the future. So that may be more what we're looking at versus just outlawing non-competes altogether. Non-solicits, both customer and employee non-solicits and non-disclosure provisions, will probably be fine moving forward, at least for the next few years. But I think it's those traditional non-competes, the one that say you can't go work for a competitor for a certain amount of time, that are going to be the ones with the big target on their back. And I've already seen some clients say, really all we care about is our customers, our clients, our employees. We're okay with having our employees go work for a competitor as long as they don't go after clients. So they're already taking that proactive step. But for the time being, those traditional non-competes are enforceable. They do work for particularly high-level employees. We're just going to continue to keep an eye on it and, check back with us in a few years. Don't go too long without visiting the dentist or checking in on non-competes. We'll keep you posted.
Excellent. Thanks very much, Scott and Caitlin. Really useful stuff. I'll just emphasize that last point that Scott made. Many clients come to us and say that they want to implement a non-compete. We talk about some of the challenges that there may be and engage in that discussion about whether a good customer client non-solicitation provision or employee non-solicitation provision can accomplish all or most of what those businesses are looking for. Time for our last poll question. Let's do some more benchmarking. Does your company have employees sign restrictive covenant agreements as a condition of employment? No. Yes, but only a confidentiality or non-solicitation agreement, so not a true non-compete. Or yes, we have them sign non-compete agreements. I'm interested to see what the balance of the group here says. So please go ahead and input those answers. All right, let's push those out. Looks like more than 60% of the folks here on the seminar today do not have any kind of non-compete or restricted covenant. About 16% have employees sign non-competes, and about 20% use that confidentiality or non-solicitation agreement. My editorial comment here would be that I think the majority of businesses would probably benefit from having employees sign some kind of confidentiality agreement, even if you're not interested in a true non-compete. That's a good way to sort of protect key information within your business. We're now going to transition to our last segment here. One of the things I love about Husch Blackwell is that we've got labor and employment attorneys who do everything. We've got folks who litigate. We've got folks who practice in the health and safety space. And here we're going to hear from two of our folks who specialize in traditional labor and employee benefits law. So I'm going to welcome John Anderson and David Eckhart to talk to us about those two topics.
Great, thank you. We are very interested in being the cleanup hitters here on this segment. So I'm going to talk about traditional labor law issues, and that doesn't necessarily mean that I'm talking about you as an employer that just have unions. It applies to all employers in the country. As a labor lawyer, I take great comfort in the fact that I can usually find a case to support anything my client does. That's going to become more difficult over the course of the next 4 years as labor policy in the United States changes and we have a very strong labor president. In fact, one of the campaign promises of President Biden was to become the strongest labor president you've ever had. And we saw that when he was sworn in on January 20th, when he fired the general counsel of the National Labor Relations Board, Peter Robb, just hours after he was sworn in. Biden then went to work immediately to establish the board in his vision. And what he did was he made Lauren McFerrin the chair of the board. Lauren, and having some of the background information about these members of the board is very important from the standpoint of understanding the context in which they bring to their positions. Lauren McFerrin became chair. She was the chief labor counsel for the Health Committee in the Senate, the Health, Education, Labor, and Pensions Committee. Then we had Gwen Wilcox appointed and confirmed in July of this year, just a few months ago. Gwen is a union side attorney, so that signals a sharp turn to the left. But at the same time, she's the first Black woman to serve on the board since its inception in 1935, which I think is significant. And she's the first member of the board to be sworn in English and in Spanish, also significant. The board is making an effort, and the president is making an effort, obviously, to have some diversity in inclusive candidates on the board. Democrats now hold a majority of the seats on the board. David Prouty was confirmed in August. So we have 3 of 5 seats held by Democrats. Prouty was a former general counsel to the Service Employees International Union and also the chief labor counsel for Major League Baseball Players Association, again, which gives us some indication as to how they're proceeding. So with Democrats holding 3 of 5 seats, we're going to see a turn to the left. We're going to see a resurgence of reversal of pre-Trump decisions and Trump decisions in the board. So after the appointment of these board members, and certainly in concert with the firing of Peter Robb, Peter Orr was then named as interim general counsel. He went right to work reversing memos that Peter Robb had been issuing. He withdrew a complaint alleging that the employer impermissibly supported a union by entering into a neutrality agreement. He withdrew the general counsel's brief in a decertification action that dealt with the preclusive effect of a contract bar. And of course, Scabby the Rat, the inflatable that we see at labor disputes, he requested that the board dismiss those complaints because they don't believe that Scabby the Rat is coercive at all. Then my friend Jennifer Abruzzo was nominated and became the new general counsel at the National Labor Relations Board, effectively at the end of July. She had been in a variety of positions at the board for 20 years, and immediately prior to her appointment was the strategic counsel for the Communication Workers of America. The general counsel is independent of the board. That's the way it's set up. She has the responsibility for investigating and enforcing the law through unfair labor practice prosecution. She also has general supervision of the NFL field, or the NLRB field offices, which includes one here in Milwaukee. 3 weeks after she assumed office, Ms. Abruzzo issued a memo, which is really a blueprint for changes that we are going to see coming in over the course of the next several years. Now, to be fair, it's much similar to what Peter Robb did when he was appointed to the board. A few weeks after he was appointed, he issued a kind of a memo which had the similar effect. The general counsel's memo is not binding. The board is not obligated to follow it. Not everything that she says will become a change, but they will pay attention to what she's saying. And of course, we don't know whether the federal courts will enforce those types of provisions. But she's usually able to accomplish the majority of the agenda, and that's what's concerning to us. We should prepare for changes in a variety of different areas. Employee handbook and technology rules, for example. In 2017, the NLRB gave us a framework for evaluating handbooks, which I thought was pretty useful. The 3 categories of types of rules, the ones that are lawful, always lawful, the ones that are subject to individual scrutiny, and the ones that are always unlawful. The new memorandum suggests that the general counsel's office is going to look for ways to tighten up the control that they have over handbooks and technology rules, which includes both employers that have unions and employers that don't. The memo suggests also that the general counsel wants to open the door for employees and union organizers to use employer email communication systems for purposes of organizing. Occasionally, union organizers come on your premises, and for example, in hospitals, the public cafeteria is a very fertile ground for communicating your views as a union adherent. And a few years ago, the NLRB decided that employers could restrict access to those things. And now, of course, we're restricting access everywhere because of COVID. But at the same time, I think you're going to see that rule be revisited by the National Labor Relations Board. Employers want the ability to make changes to labor contracts, changes to things that are covered by labor contracts. And in the past, employers have had the right to do that under a recent decision of the National Labor Relations Board. Recent, I've been practicing for 40 years, so that could be within the last 3 years, of course. But certainly that allow the board, the board is allowed for changes by the employer in situations where the employer can say, hey, the contract covers this. In past situations, pre-Trump, or during the Trump era and earlier, there were concerns that you had to show an unmistakable, clear and unmistakable waiver. And that's something that we think the board's going to move away from. The arbitration agreements and class action waivers in 2019, the board said, hey, employers, you can discipline employees who refuse to sign mandatory arbitration agreements. And we think that that's going to be revisited by the current board. Abruzzo's agenda includes scaling back employers' abilities to govern civility in the workplace in certain circumstances. And under a more recent decision, employers had the ability to restrict access, or excuse me, to restrict and to regulate the conduct of individuals, even if they were engaged in protected concerted activity, if they were doing it in a way that was hostile or not civil. And we think that there will be a reversal of that during the course of the next 4 years if the right case comes to the board. We think that the time-honored decision of whether or not an employee who is not represented by a union has the right to exercise, has the right to have a representative present in disciplinary situations. We think that's going to come back before the board again. Again, in the 40 years that I've been practicing law, that has flip-flopped 3 or 4 times. Not unusual when the presidency changes and when the nature and makeup of the board changes. We think we'll see rules for investigation of workplace misconduct changing. Sharing information with the union will be required again, even though in the most recent iteration through the Trump administration, that was restricted. Employers may have to bargain with unions over discipline in situations when a union is coming on the scene for the first time, even before there's a labor contract in place. We also think that the board's going to assert jurisdiction over the employment aspects of a religious education institution, despite case law that suggests otherwise. We think that the issue of independent contractors is going to be an issue where the board will make it harder for a worker to be classified as an independent contractor. And of course, when you're bargaining a collective bargaining agreement, up until, current law allows you to stop the dues deduction when the collective bargaining agreement expires, which gives you tremendous leverage at getting an agreement at the bargaining table. That change was made during the Trump administration. We expect that that change will revert back to pre-Trump law, which was that dues deduction will continue. We also see the board expanding monetary damages to include consequential damages. So the board has the authority now to award back pay and reinstatement. We think consequential damages would come forward. So an employee who loses their job, they're going to get reinstated, but they're also accruing bills and paying interest charges on bills and paying for health insurance that's not health treatments and procedures that insurance would normally cover. Those are all things that we think are going to be opening the door. Lastly, in terms of, we also see a make-whole remedy being increased, where employers will be issued large monetary fines of $100,000 in repeat situations. It's a concept that the Democratic congressional members have recently endorsed as part of the House Labor Panel's proposal for congressional budget reconciliation. In other words, it's all about the money. Let's get some money back into the government. And it's an open question whether the NLRB has the authority to do that and whether or not the courts will support that. The NLRB is limited by the NLRA, which says back pay and reinstatement. We'll see more use of the 10J injunctive relief, the discharges that occurred during an organizing campaign, and for the situations that are listed on the slide here. And the difficulty here is that most federal judges give great deference to the regional directors that are seeking this injunctive relief. So how is she going to do this? How is Jennifer Abruzzo going to do this? She is, again, in charge of all the regional offices. There's 30 of them in the country. And when these cases come up, she's told the regional directors to get this information to my division of advice. And what we will do is then centralize our consideration of these issues and find the right cases to bring to the board so that the law can change. So pro-labor, yes. Return to pre-Trump precedent, absolutely. There's a new sheriff in town. You need to make sure that you keep track of these developments on the Husch Blackwell website or on the NLRB's website. And now to David to bring forth some hot new issues relating to employee benefits.
Thanks, John. Appreciate it. Dave Eckhart, partner in the Milwaukee office in the employee benefits practice. We only have about 5 or 6 minutes left, so clearly I'm not going to be able to cover a lot of this employee benefits stuff in detail, but and some of the stuff may not be applicable to you or you know what your role is with the company. But we did about a month ago, we put on a whole employee benefit update webinar by ourselves with our employee benefit group. We covered retirement plan updates, we covered health plan updates, and even after that hour-long presentation, we thought, hey, we could do our own presentation just on retirement plans and just on health plans. So there's a lot of information. There's a lot of updates that need to be made to employee benefit plan documents. I'd suggest you take a look at what we have on our website if you want more detail on that. But I will cover just some high-level basics on employee benefits. There have been a lot of changes over the last couple of years. Much of it has been driven by the pandemic and a lot of the laws that have come out as a result of COVID. Some changes were a result, though, of just simple legislative changes and updates to retirement plans in particular, and health plans as well. There's a link there to our year-end deadlines and updates for benefit plans that you should definitely take a look at. Real quick, a quick statement on retirement plans. We're seeing a lot of this. We're helping a lot of clients work through this. But if you're on a pre-approved document, which is known as an IRS pre-approved document, those need to be updated by July 31st, 2022. And so what you need to do is you need to look at the old plan document that you have. You need to look at the new one. You really have to do a kind of a line-by-line comparison, making sure that nothing is inadvertently changed. And I can tell you, in the documents that we review, usually there's something that needs to be changed in the new document. And if you don't catch it now, it can become a problem later on. So that's just a reminder to, if you haven't done your document restatement yet, to be on the lookout for that in the coming months. If you're on an individually designed plan, this really doesn't apply to you, but most plans these days are on the pre-approved format. Some other changes worth noting, there were some changes in hardship distributions. And those hardship distribution amendments have to be made by the end of this year. So if your document is not set to be restated until next year, we got to make sure that your document is amended this year to at least include the hardship changes. We have the Secure Act that was promulgated before COVID, and then we have the CARES Act that was issued as a result of COVID. And quickly on the hardship distributions, we got a lot of different changes that apply to hardship distributions. There's a different test than there used to be. There's additional sources that are available to take hardship distributions from. So when you're implementing these changes, you really got to understand the differences and the changes that were made as a result of the legal changes, and make sure that your document is updated to reflect anything that you've changed with your plan over the last couple of years. The Secure Act adds a part-time eligibility provision for employees that work 500 hours or more for 3 years consecutively. They are now eligible to become participants in your 401k plan. So that's something that has to be changed from a documentation standpoint and from an operational standpoint. We have an extension of the required minimum distribution age to age 72, and we have some birth or adoption assistance distributions that are available. So if you haven't made those changes yet, or you're looking to make those changes, check the rules on these, check with your retirement plan, third-party administrator to see if those changes should be implemented in your plan. The CARES Act kind of loosened some rules on loan repayments. It offered an opportunity to take distributions up to $100,000 for coronavirus-related matters. There's some kind of nuance there on the tax reporting. Again, you should work with your third-party vendor on making these changes, and then come to us to, with any sort of specific questions or with any sort of nuanced questions. Health plans, a ton of changes with health plans. We have the CARES Act, we have the FFCRA, we have CAA. All of these included some changes to either health plans, cafeteria plans, FSAs, DCAPs. And so there's just a litany of changes that need to be updated for those types of arrangements. Here's a list of some of the changes. Again, this list goes into more detail on our website. Mental health parity, I just want to mention this. This is something that we're seeing a lot of enforcement around. The DOL has started asking information from health plans about mental health parity. You should definitely be working with your consultants, your insurance carriers, and your legal counsel to make sure that your plan complies with these mental health parity rules. This is more of a problem, I think, for self-insured plans than it is for fully insured plans, because you're relying on the carrier to comply with these rules. But in any event, you should be monitoring the mental health parity rules. Real quick on executive compensation, the last thing I'll mention here in the last minute, nothing really new, nothing really changed from a legal perspective, but just one thing to remind you of, that deferrals for 2022 need to be in place by December 31st, 2021, generally speaking, on a calendar year plan, because without those, we can have some 498 complications. So just keep in mind that if you have a deferred comp arrangement, we got to get those deferrals in by the end of the year. So with that was a very quick overview of employee benefits. We could spend hours, but Eric, I will turn it back to you.
Thanks, David. Thanks, John. Really terrific overview. I sit right next door to Dave, actually, here at the office. I'm in his office fairly frequently, as you can imagine, when I get questions about the sort of issues that he just covered there. It's a great resource that we can have. And I think Dave highlighted some of the things for you to look out for and some of the resources that we've got on the website for those of you who are interested in more information. That concludes our presentation. I've got a couple closing comments here. Thanks for joining us today. We hope that the information was helpful to you and your organization. As I mentioned at the top, recordings of our previous sessions are available on the website, and a recording of today's session will be there soon. You will also, if you're an attendee, receive an email with a link to that information. The final presentation in our L&E series is our Colorado program. That's scheduled for next Tuesday, November 16th. If you do business in Colorado or are considering doing business there, I would strongly encourage you to watch that session. There have been lots of important developments in Colorado labor and employment law recently, including some equal pay and pay transparency laws that apply to many employers that have only a de minimis connection to that state. Final reminders, this program has been approved for HR and legal education hours. To report your hours, click that CEU icon on the bottom of your screen. A certificate of attendance, including those course numbers, will be emailed to you tomorrow, along with the recording of the webcast. Finally, please be sure to complete our short survey. We'd like to use your feedback to plan our future programs that are applicable to your business needs. Thank you so much for joining us. We look forward to seeing you all in person, maybe someday soon. Have a great day.